I thank the chair. Good morning, everybody. Appreciate your testimony. Wanted to start with Mr. Hammock. These letters of interpretation, that's what you're talking about being put on the website. They have the weight of law, right? At the time they go on the website, or is there a formal publication process that must be gone through first?
I mean, there is not a formal publication process as you would think in terms of a rule that needs to be published in the Federal Register. They are made publicly available usually a few months after they are sent to the requester. So the information is out there for a period of time before they turn up on OSHA's website. You know, with respect to whether they have the force and effect of law, OSHA's position is that, as was discussed earlier, is that they don't. But the reality is some of these letters of interpretation do go quite far in setting out employer obligations. And I've certainly been involved in cases where a compliance officer has showed up on a site and handed a letter of interpretation to an employer and said, are you familiar with this new position that OSHA's taken? And it's gone from there.
Yeah, but I thought the testimony, and maybe it was an amalgamation of everyone's testimony, showed that the trend is different. Like, so, for example, in the past, letters of interpretation were intended to be clarifications of existing policies, and that wouldn't require any specialized legal notice. But now, if I understand Mr. Baskin's testimony correctly, these quote-unquote letters of interpretation suggest more than a simple clarification, and that's what you're describing, right? So now
Correct.
You have a different situation that could have the force and effect of law, yet we're giving notice by website and maybe soon by Facebook. You know, who knows? And that's where we have, you know, some problems, not only for industry and businesses, but for the agency itself. Now, you worked at the agency, correctly? Right, correct?
That's correct,
Yeah.
Yes.
Ms. Rabinowitz's testimony laments the length of time, on average 7 years, that it takes for OSHA to promulgate a regulation. Are the requirements OSHA must follow in place for specific reasons, that's the reason it's taking this long, or what's the situation?
Yeah, there are some procedural requirements that OSHA needs to follow to promulgate rules, and those are, for good reason, to get input from a number of stakeholders as early in the process as possible. Those requirements in and of themselves are there for good reason, but they don't cause an undue delay in my experience. There are a number of reasons why OSHA may take a long period of time, and I have been a part of some of those experiences when I was with OSHA. But they're really outside of those regulatory procedural things that OSHA has to do, which, as I said, are really to provide additional input from the agency, which can be real value added for the policymakers there.
Thank you. And then turning my attention to Mr. Baskin, Mrs. Rabinowitz's testimony highlights that employers can refuse OSHA access to a job site and require the agency to seek a warrant. And we've been touching on that. You, however, note that employers might be reluctant to do this because it could engender animosity with the inspector. Not hard to imagine. At issue, though, is that OSHA would be seeking a warrant to allow participation by a third party who is not a designated representative of the Secretary. Do you believe OSHA will be successful in obtaining a warrant that allows a third party to accompany an inspector?
Well, I'm always reluctant to predict what judges will do, but the law seems pretty clear in this situation. Because of the violation of the Administrative Procedure Act, if it's contested, OSHA should not be successful. And I would add to the problems that employers face, first is lack of knowledge of what's going on. There was, Chairman Klein asked about the website. This letter that we've been talking about on the union access was issued in February, but was not even posted, was not made public anywhere until April. Months went by while there was nothing on any website for anyone to turn to. And now, even after it's been published, there's an extreme difficulty in making the employers aware of what's going on, because they're not all sitting by their computers watching the OSHA website. They're actually engaged in business, trying to do what business people do and succeed and survive in this economy. And so they are taken totally by surprise when this happens. Then if they have the wherewithal and are willing to stand up to the OSHA investigators. I got to call a lawyer, not something they're all fond of doing. That lawyer has to be familiar with this issue. It's a fairly narrow thing, so not many lawyers are. OSHA has the ability to go in to get the warrant ex parte unless the employer and their lawyer make special efforts to show up and contest it with the judge. So these are all reasons why this is just not the way to do business. This is why you have an Administrative Procedure Act, and this is why they should not be making these kind of changes without going through the public notice and comment.
Time's expired.